a rebuttal, then you'd be raising new or additional grounds, or you would be re-arguing what you've already argued.
Yes, Your Honor.
Thank you very much. All right, so then that puts us at the time to announce a verdict. Of course, we want to stress that the verdict or outcome of the case itself has no bearing on the performance of either team, the scores of either team. What I will find and rule is that I will find the defendant not guilty of the crime charged, with the reason being that the beyond reasonable doubt is that it's a very high standard that you will hear. And as if you look through the legal authority portions in the case packet there, that's some of the jury instructions that are always really helpful, including there's the one that the elements of the murder. They also have one regarding circumstantial evidence and the sufficiency to prove somebody guilty. And one of the points we can hear from our public defender over on our scores, but one of the circumstantial evidence, one of the instructions states that when there are two reasonable conclusions that can be drawn from circumstantial evidence, the law requires the jury, or in this case the judge, to choose the one that points to innocence. So whenever that's a carrying out of the proof beyond a reasonable doubt standard, the presumption of innocence that a defendant is always entitled to. So given the facts that were presented, there were, from my perspective, a couple of reasonable inferences that could be drawn. It could very reasonably have been the putter, and it could also reasonably have been the trough from the bathtub. So given that they're both perfectly reasonable inferences, the law would require me to favor the one, choose the one that points towards innocence. And so that is the reason for that. And I actually skipped over, we need that 30 seconds for the conference, for the rules, any rules violations, anything that was, procedural rules would have been waived, but any extraordinary rules violations, I guess that was actually before we go any further. Part of the program is you had to have the opportunity to consult with your coaches for that 30-second interval to see if there was any substantial rule before we get to the scoring, finalization, or anything. So I want to make sure I give each of you that opportunity to consult with your coaches on that if that's necessary. Anything from the...
Nothing but offense, Your Honor.
Anything from prosecution?
No, Your Honor.
All right, thank you very much for that. Alrighty, then the next thing I will do, in order to make sure that scorers have the time to complete their thing, is ask you to conference among your own team about selecting someone from the other team as an MVP. So I'll give you a moment to do that while the scorers complete their score sheets. Go ahead and start the prosecution. Want to present yours?
Yes, Your Honor. The MVP award, we chose Alex Davis.
We'd like to award to their pretrial attorney, Alex Quezada.
And then I'll turn it over to our scorekeepers for their thoughts and comments here.
Well, you guys did an amazing job. I've done this a couple of years now, and I'm just always super impressed by how well you know your facts and just how much time and effort. I can tell that you all put in a ton of hours on it. So good job. I think you were better than me on my first like real trial in real life. So that you guys should be proud of that. Something that I kind of want to just echo that the judge talked about beforehand, that it's good to just listen. I know you get super nervous and you want to stick with your script, but sometimes the witnesses will tell you something, or the question that the judge asks you, make sure that you listen, even though you're super nervous, because if you can follow up on that, it might be a really good nugget for later on. The witnesses for Tribuco, you guys did awesome. I liked how you memorized the prosecutors' names, so that when they said good morning or good afternoon or good evening or whatever, you responded with their name. I thought that was a nice touch. There was a little bit from the defense team, a little bit of commentary like, oh, interesting, things like that after the witness would answer. And I'm guilty of that too. I tend to do that. But try to kind of nip that a little bit. Just let the witness answer, and then also the interrupting. That's a style thing, and if that's something that you feel confident in and comfortable, where you interrupt the witness and say, you've answered my question or something like that. I tend to be more of if somebody's not answering my question, I just let them. And then I'll say, well, that's not really what I asked you. Or I would just ask the court, I would say objection, non-responsive, move to strike, and then move on. And it's kind of, that's a style thing, but it tends to kind of be offensive if you just like try to talk louder or over the person. What else? Alex,
Yes.
your closing argument was like 100% spot on. I loved it. You had a ton of actual facts about the case, and you had it memorized. Like that's in your brain. Like we know that, but you would have been a court reporter's nightmare. Like you're too fast. And I get that when we get nervous, or when we're like when I'm reading jury instructions and stuff, I'll have court reporters just like straight up stop me and be like, you need to slow down. So just be confident in the fact you know this case. Like you know it probably like maybe the best from what I could gather. So next time you do this, just be like, right before you get up, just like calm your heartbeat, take a deep breath, and just be like, I'm just gonna hit it out of the ballpark. Like you know it. So I think that's it. Good job, everyone.
So this is my first time scoring, and you guys are great. I mean, if anyone was nervous, I had no idea. I mean, each one of you had a really good presence. The witnesses, the witness who played the detective, it was
Perfect cop.
hysterical because it was almost realistic in a lot of ways. It was, and all of the witnesses really got into their characters, and in a way that you knew the material really well, and I liked the way that you responded to the questions. It was great. You guys did a really good job. The two students who did the pretrial motions, I thought you guys were fantastic. I don't know where, there she is, yeah. You guys, those are very sophisticated arguments. I mean, I can't believe, I thought you guys were law students. You knew the cases really well, you compared it to the facts in your case. I just thought you guys were phenomenal. It was really great. In terms of the defense, I thought you guys had this like emotional hook to your case, that filling the void, and it carried through from the beginning all the way through the questioning of the witnesses. Noah, in your cross-examination, it was almost like the answers didn't matter. You were just asking these questions that had a narrative all of its own. So that's what I was listening to, and it just was really well done. I wrote so many things. You guys just really, really good. I really like the direct examination of the prosecution team. It was really calm, and it wasn't over dramatic. It was exactly what it's supposed to be, just eliciting information. So I thought it was great. Yeah, I'll definitely do it again. You guys are wonderful.
So this is my first time as well, judging everyone, and it's, all I can say is wow. Very, very phenomenal. You guys can tell that you guys prepared so well. You know your facts in and out, your objections, everything. I'm very, very impressed. I just have general phrases like, I definitely think you beat a lot of the law students out there during our mock trial team. You guys are very, very good. So great job, everyone. You should be very, very proud of yourself, especially all the confidence that you.
Oh, and additionally, on the prosecution team, you guys had this, I liked how you emphasized, I think each one of you did it, like 3 points that you kept coming back to, and especially at the beginning. That's a great technique, and I just noticed it seemed like each one of you was doing it, so it was really great.
And sorry, one more thing.
No, please go ahead.
The part I was listening to you when you were answering, I forgot your name, Jocelyn. And I didn't mean to point, but when you were saying one of your answers, you were like, oh, okie dokie, you know. I mean, that's like, it just shows like your personality. And so sometimes I think we get up there and we become robots, and it's just cute, like it's endearing. And then the other thing is, when there was an objection, a hearsay objection about like somebody overhearing a fight, and it was overruled. But then I just want to say, don't give up, because if you think like, okay, maybe it was overruled on that point, but then the person keeps asking questions about the actual content of the fight, that's hearsay again. So you guys can continue your objection. Just because you were shut down the first time doesn't mean that you shouldn't. If you think it's hearsay again, go ahead and do it, you know, and the judge might get annoyed or whatever, but it's okay, it happens. It happens.
No.
Not this judge.
There was one, I think it was one of the objections where it was, I'm not sure which, where it was overruled, but then an answer was never obtained.
Yeah.
So you always got to make sure that, you know, obviously if the objection is sustained, you don't get a response. But if the objection is overruled, make sure that you get an answer from the witness.
Right, and if it's sustained, one of yours was sustained, but you didn't move to strike, so it's still there.
I think
It's
Noah,
technical.
you did.
Yeah.
That's good.
But awesome.
Good job. Yes, I'd just like to echo their comments. Yes, I've only done this a couple of times, but I'm always thoroughly impressed. It's not an easy thing to do. I mean, there's no way in high school I would have stood up and done anywhere near this caliber of work with this. And so you all do deserve a thorough round of applause for the wonderful work. And the work that you put in preparing for this comes through, because you do. Both sides knew the material so very well, and it was very impressive. There's a couple of the, I guess, broad suggestions for me, and I don't know, I guess I'm a little bit of a law or rule junkie. So the things that I always like to see are, as I went back to the authorities, is what's the law, and then put the facts to it. So from the prosecution's perspective, you know, what are the elements of this crime? You know, if I'm going to get a conviction of the person, then you need to be able to see, there's the jury instruction in here that lists out the elements of the crime that's charged in here. So you need to make sure that you can put a check mark next to each one of those. You know, there's 3 or 4 elements. You go, element number 1 is this, and then if you direct the jury or the court to what evidence satisfies that element, then you move on to the next one. So it's kind of like a recipe, a little laundry list. Okay, I got a check mark next to everything. That means we get a conviction. And then same thing as I mentioned from the defense perspective. I'm a little bit of, again, a law junkie, and like the presumptions that go in your favor. And so those things that you've built up a lot of time, justifiably so. Especially this fact pattern here, when you've got both sides, it's potentially made to be very reasonable inferences drawn in favor of both sides. And so when this law is very clear that